Guardianship matters. These are taken from court documents and other letters in the case CP 0136-2009, Superior Court of New Jersey, Essex County, Chancery Division, Probate Part. This is taken from a request for sanctions against Vanessa D. Taylor for $250,000. The court order filed February 3, 2010 in this matter on item 13, page 4 states, quote, "The guardian shall keep all family members, including Gary Juan Johnson and other persons of interest, advised of any matters or issues involving the best interest of Robert J. Johnson, including medical care and his residence and sale of property. Vanessa has failed to follow this court order." And as an aside here, the word any, as in any matters or issues involving the best interests, the word any is defined as everything. As we continue, let's see what we have here. I was told by a knowledgeable family member that it took Vanessa from October 2009 to past April 2010 to get the key to Dad's building. That is 6 months to do something that should take 1 day. On April 21st, 2010, I faxed real estate person Samuel Pica of Newark, New Jersey, asking him to give specificity for his comment that Dad's building could not sell for less than $100,000 because of Pica's claim of the large amount of Dad's bills. Neither Pica nor James Boutillier has contacted me with that information detailing why Dad's bills have skyrocketed to over $100,000. Again, we are reading from documents turned over to Judge Walter Koprowski and also Judge Joseph P. Brennan in the guardianship case CP-0136-2009, Superior Court of New Jersey, Essex County, Chancery Division, Probate Part. We're reading from documents, some of them are court documents, pleadings, and some of them are letters and faxes and emails. To continue with the motion for sanction against Vanessa D. Taylor, I have not received adequate answers to my concerns, nor answers with the required specificity. I request the court, under its own motion, grant sanction against Vanessa D. Taylor in the amount of $250,000 payable to the court for disobeying the court order filed February 3rd, 2010. And that amount of sanction has been amended to a $1 million sanction against Vanessa D. Taylor. Now we're going to read from the response and certification in opposition by next of kin to July 29th order to show cause from surrogate. Again, this is the document served on the court, asked to be filed, and also sent to the court in letter and email format. Response and certification in opposition by next of kin Gary Juan Johnson to July 29th order to show cause from surrogate. The surrogate Joseph P. Brennan submitted an order to show cause in order to sell the property of Robert Johnson, and this is one of the oppositions to that order to show cause. Again, we are only quoting from part of the opposition. I hereby enter my objection to the order to show cause, filed July 29, 2010, and authored by Judge Joseph P. Brennan, Essex County Surrogate, and to any and all other papers related to the order to show cause that might have been served or filed by the surrogate, the guardian, and James Boutillier that were not served on me and not in my possession. It is my belief that the order to show cause hearing should be canceled as invalid, as there was no valid proof of service of the order on next of kin or interested parties. On my own initiative, I was able to receive a courtesy copy by fax upon request to the judge's secretary on August 27, 2010. Without waiving the voidness of the order, I offer the following additional objections should the matter be heard on September 3, 2010 or otherwise, and I ask that the order to show cause be denied. I believe Vanessa D. Taylor, along with the help of others, has engaged in guardian fraud, guardian mismanagement, and breach of fiduciary duty. I believe the order to show cause should be denied because Vanessa D. Taylor, along with the help of others, has engaged in guardian fraud, guardian mismanagement, breach of fiduciary duty, as reported to the court, to James Boutillier, and to the Essex County Surrogate. The court order filed February 3rd in this matter states the guardian shall keep all family members and other persons of interest advised of any matters or issues involving the best interests of Robert J. Johnson, including medical care in his residence and sale of property. Vanessa has failed to follow this court order. As reported by facsimile, United States mail, voicemail, and/or email to this court, Dad's court-appointed attorney James Boutillier, and to Essex County Surrogate Joseph P. Brennan, Vanessa has not kept me advised on Dad's medical care and residence and property. I was told the building needs extensive repairs, and thus I believe the value of the property is lower than $100,000. On April 11th, I emailed family members as well as James Boutillier, attorney, that parties should not in any way interfere with my rights granted to me by the court order in this matter. On April 2nd, 2010, I faxed real estate person Samuel Pica, asking him to give specificity for his comment that Dad's building could not sell for less than $100,000 because of Pica's claim of the large amount of Dad's bills. Neither Pica, Boutillier, or Vanessa Taylor has contacted me with that information detailing why Dad's bills have skyrocketed to over $100,000. I ask through this opposition that James Boutillier forward me copies of any and all motion or otherwise papers authored by Vanessa Taylor or her attorney if she has one, and Essex County Surrogate, or any other papers related to the order to show cause that are dated after February 3rd, 2010 to today's date. The order to show cause only mentions about $10,000 in fees owed to attorneys. This does not seem a valid reason to sell Dad's property in view of the fact I estimate between rents on the income property and Dad's Social Security and pension, Vanessa since October 2009 should have amassed about $45,000. I ask that Vanessa Taylor be compelled before such order to show cause is refiled to explain where is the $45,000 estimated and why did she not use that to pay the $10,000 in attorney fees. In the best interest of Dad, I think the order to show cause should mention that the sale of property is to be used to pay for Dad's medical bills, and then of course detail what those bills are. There's no mention of this in the order to show cause. I do not believe the expenses of Dad's medical care and nursing home care, if needed, should be handled in such a vague, lacking in specificity, haphazard manner as is done in the order to show cause. I believe it would constitute fraudulent concealment, negligent concealment, and intentional fraud to advise on Dad's medical care and residence and property in such a vague, lacking in specificity, haphazard manner as is done in the order to show cause. I believe it would constitute judicial misconduct, unethical conduct, abuse of discretion, abuse of authority, and abuse of process to advise on Dad's medical care and residence and property in such a vague, lacking in specificity, haphazard manner as is done in the order to show cause. I asked the surrogate to cancel and take off calendar the order to show cause on the grounds it is marked by fraud, and on the ground there has been no valid service of the order to show cause. Vanessa D. Taylor is the owner of the Taylor Group, and according to the company website is an insurance brokerage and risk management and consulting firm. The website claims broker assignments to commercial accounts, municipalities, and businesses. I understand Vanessa D. Taylor is also a real estate agent. On August 4, 2010, I wrote Honorable Judge Walter Koprowski by United States Mail and informed him that I believe Vanessa Taylor was acting with discrimination and fraud and withholding details of Dad's property. I faxed Vanessa Boutillier and Pico that they had not made full disclosure to me as regards Dad's property and that they have failed to disclose all known facts of the property on August 14th, 2010. Again, this is taken from court pleadings served or filed or email or letter format to the court in this matter, and this is a guardianship matter in the state of New Jersey, Superior Court of New Jersey, Essex County.